Madam Chief Justice, and may it please the Court. My name is Monica Haddad, and I, along with my co-counsel, Alex Landback, represent the petitioner, Mr. Samuel Millstone, in the appeal before this Court. Mr. Millstone respectfully requests that this Court reverse the decision of the 14th Circuit Court of Appeals because their interpretation of the term negligently in the context of Section 1319C1A of the Clean Water Act should not be a civil standard of negligence, and additionally, notifying a potential witness of their right to invoke their Fifth Amendment is not satisfy the phrase corruptly persuades in the context of Section 1512B3. I will be addressing the Clean Water Act, and my co-counsel will be addressing the witness tampering statute. The holding of the 14th Circuit in regards to the Clean Water Act was incorrect for two main reasons. First, a civil standard negligence standard is incorrect in the context of a criminal statute, and additionally, the Clean Water Act is not a public welfare statute.
Can you address the public welfare statute first and then the negligence issue, please?
Yes, Your Honor. According to this Court's framework for determining when a statute is a public welfare offense, there are several factors which came out of this Court's decision in Staples versus United States. First of which would be that the statute would be trying to deal with the regulation of potentially dangerous or deleterious items. A reasonable person would be on notice of the regulation.
But isn't dumping pollution into America's waters, isn't that a hazard, and shouldn't that be a public welfare statute of protecting our waters and keeping our waters and similarly our air clean?
Yes, Your Honor, that is, it does seem to be that anything potentially dangerous would fall under a public welfare statute. However, it is not dispositive according to this Court's opinion in Staples. Instead, one must look to the other factors such as a reasonable notice of a regulation and also the fact that there are light penalties involved. In this case, Mr. Millstone is an independent security contractor. He's being penalized for providing a security plan to a large chemical company, which unfortunately there was an accident that occurred and now he's being held criminally liable. Instead, additionally, the fact that he was convicted under 1319C1A based on a violation of 1311, which states that, and I quote, "the discharge of any pollutant by any person shall be unlawful," is too broad of a standard to be considered a public welfare statute. A reasonable person, anybody, the cleaning lady, could be dumping some kind of cleaning agent down the drain and she could be potentially liable under this statute. It just doesn't make sense in this case to hold someone criminally liable for a regulation that they would not know in this case.
But shouldn't he know it? He worked it as a security guard for a chemical company and sort of the gatekeeper who should know those statutes. I mean, he wanted to work for this company. He sort of expedited the process and moved it along. How can you say that he should not be held liable of sort of this dumping? I understand that, a cleaning lady, I get your analogy, but how can you say that Millstone should not be held liable in this situation?
Your Honor, Mr. Millstone was not directly, as you stated, not directly involved in the chemical production, and to hold him liable would just be trying to find the blame in this case. As indicated in the record, Bagel Chemical Company relocated to China. They could not find any of the company executives to hold responsible for this spill. He seemed to be the only other option. And instead, this Court should restrict the public welfare doctrine, as it has consistently done, and protect the rights of this defendant in this case. Additionally, as this Court has stated in the denial of certiorari for United States versus Haddad, the Ninth Circuit Court case, which found this regulation to be public welfare, Justice Thomas, the same justice who wrote the decision in Staples stating that the public welfare offense doctrine needs to be limited in scope, pointed to the fact that in this case we would be criminalizing ordinary industrial and commercial activities. Again, going to the notice, independent business contractors would not be on notice that they would potentially be liable under this statute and face criminal penalties. As to the last factor for the public welfare offense doctrine, one would look to the light penalties. In this case, we do not have light penalties. As indicated in the statute, there's a minimum fine of $2,500 per day, up to $25,000 for each day of violation, and up to 1 year imprisonment. Putting someone in prison for a year seems quite drastic and is not a light penalty that would not harm Mr. Millstone's reputation in this case. Going back to the term negligently in the context of 1319C1A, in the context of a criminal statute, the correct interpretation in this case should be a gross standard of negligence, which is consistent with criminal negligence standards, as this court stated in United States versus United States Gypsum Company when trying to construe a criminal provision of the Sherman Act, which, like the Clean Water Act, includes both civil and criminal penalties. This court found it important to look to the Model Penal Code for guidance in the absence of any definition from Congress. In this case, Congress did not define the term negligently in 1319 C1A. Therefore, this court has the responsibility of determining the correct standard in the context of a criminal statute. Additionally, looking to the civil standard of negligence in the context of a criminal statute is not consistent with this court's opinion in Safeco versus Burke Company, where the court stated that looking to the civil side would not be consistent with the purpose of a criminal statute and would lead to incongruent results. Additionally, this court should take a more holistic approach to the structure of the statute as a whole. First of all, noting that 1319 C1A starts with the title of criminal penalties. Also, there are other sections within the Clean Water Act which do include other standards of care. And for example, 1321B7D allows for the assessment of civil penalties at a gross negligence standard. However, allowing for 1319 C1A to convict someone criminally under a regular standard of negligence would lead to an absurd result in this case. Furthermore, United States versus Haddad should not be persuasive in this instance. Instead, Haddad simply
Do you have
relied...
a citation for that case?
For which one?
The case you're speaking about right now?
United States versus Haddad?
Yes.
It's the Ninth Circuit case.
Do you have a citation for it?
No, I don't have a specific
Thank you.
number. That case was in I can't even remember the year right now, but it relied on United States versus Weitzenhoff, another Ninth Circuit case in 1993, which Weitzenhoff was only looking at C2, which is the knowingly mens rea under the criminal penalty statute. Haddad just simply adopted the logic from that case that stated anything dealing with the Clean Water Act is a public welfare statute, and then just applied that to the negligently term in C1A. Instead, that court relied erroneously on the idea that anything that protects the public is automatically a public welfare offense. Instead, what we have the very next year after Weitzenhoff was the Staples decision that stated dangerousness is not dispositive. It may be indicative of a public welfare statute, but that is not the determining factor. Instead, the reasonableness of notice and also the light penalties are key. Additionally, although the facts in Haddad may sound on point in this case, as a respondent will argue, they are actually not, because Haddad, in that case the defendant, was in charge specifically of security and safety of the project he was working on alongside an oil pipeline. For many months he knew of the presence of the oil pipeline and failed to take steps to protect it, notify his employees of its presence, and take care. Additionally, he was specifically responsible for security and all efficient running of the project. Instead, what we have here with Mr. Millstone, he merely provided a service, enacted this security plan, as this record indicates, overcoming incredible hurdles to come up with this plan in 2 weeks, and was able to...
Did he come up with the plan in 2 weeks, or or was he motivated by money and wanting to get the job, and so he shortened the amount of time that he trained his employees? He sort of hired not as experienced people. So was it really him rushing to, do something in 2 weeks, or was it sort of him cutting corners to make sure he put the most money in his pocket?
Well, the plan was done in 2 weeks. Of course, Mr. Millstone was probably excited of this great opportunity to expand his business, which he started a couple years out of graduating with his MBA with one of his former classmates, Mr. Reynolds. However, the fact is he did institute a training plan. He hired 35 new security guards.
But it wasn't his typical standard of practice that he only hired security guards who had experience and had been on the job. And in this situation, I know he had to hire a lot of people, but he hired some who had a lot of experience, and then also ones who really didn't have a lot of experience. So how would you say that that was not negligence and sort of not motivated by the wrong thing?
Your Honor, looking to the facts on the record, it is true that he hired some that were inexperienced, but he also hired some who were experienced and still provided them with at least 1 week training. According to the record on page 4, Mr. Millstone was a law enforcement officer for 10 years, So one could assume that his judgment would be correct in this case, and he did exercise the standard of care, even meeting a negligence or a gross negligence standard. He has not done any acts that would be considered negligence in this case. Additionally, Your Honors, according to the rule of lenity, in this case, since we do have a statute that is ambiguous in some respects, since there is no definition of negligently, there are multiple equally susceptible definitions of the term negligently in the statute, and the factor of a public welfare statute possibly coming into play, lowering the mens rea or eliminating it at all in this case. This court should construe the statute in favor of the defendant using the rule of lenity and protect his due process rights in this case.
Speaking of due process, this indication of criminal conduct under regular negligence does away with awareness of any wrongdoing. Is that correct? I mean, he didn't even have to be aware that something was amiss or that he had done something wrong to be charged criminally?
Yes, Your Honor, that's exactly the problem with this statute, is that Mr. Millstone was not on notice of this regulation. He thought he was merely providing a security service. He had no idea, the brakes would stick, that this car would go out of control, that the tanks at the chemical plant couldn't withstand the impact. Instead, he's being charged for something he had no notice of. There would be no deterrent effect in this case. One of the main goals of criminal statutes is to provide this deterrence effect. And as Your Honor stated, by just criminalizing otherwise lawful conduct, in this case, an ordinary businessman coming up with a plan, trying to move forward in life, it would be a violation of his due process rights in this case. And for these reasons, Mr. Millstone respectfully requests that this court reverse the decision of the 14th Circuit.